I think this is the fifth or sixth time that I've come to Ukraine since the war started, as part of Americans trying to help Ukraine in this crazy and ridiculous time with this war started by the lunatic who was I would say, I was about to say, as big of a problem for us as for you. That's actually not true, but it's been a terrible problem for us as well. So it's a problem that I hope we can face together, and that help Ukraine through this time. And I first visited the campus of Irpin as a lawyer, a practicing lawyer in the United States, as well as a university professor, and looking for ways to legal ways to address the damage caused by all the Russian aggression. And while I was teaching courses at the University of Alabama, and my students were horrified to see, to try to imagine, their college campus having the kind of destruction that y'all have experienced. Is Artem with us? Artem, can you put up the picture of the administration building? I don't know if Artem is with us or not.
Oh, yes, of course. Just 1 minute.
Okay.
1 minute.
Так, Артем, давайте включайте фото адміністративного, адміністративної будівлі адміністративного корпусу нашого університету. Виведіть на екран, будь ласка. Це, так розумію, друга, напевно, так?
Yeah, there we go. And that's a picture I took on my first visit to Irpin, and I showed it to my students. And I can't tell you how horrified they were. So they are very soft, with they haven't experienced anything like what y'all have experienced. But I'm happy to be teaching this class because the world is expecting a lot from you, Ukrainian students, with what you've been through to lead the way out of this. Incidentally, it's interesting. Our campus at the University of Alabama was also it was burned to the ground. All the buildings burned to the ground during the war, the American Civil War, but that was in 1864, over 100 years ago that happened. And we thought that, the world was long past the place where something like that could happen. And so I think, this class is important, and I'm glad that so many of you were interested in taking the class, because it's, I think, a first step in cooperation between the U.S. and Ukraine, also between our universities. And I'm working to create a joint program between the University of Alabama and universities in Ukraine. And this class is the first class. So it's important and historic. And I think it's symbolic because to have a contracts class, because in the future, we hope to work together to rebuild Ukraine and build, strong economic conditions and relations between the United States and Ukraine. And contracts is really a kind of a symbolic course, because it's about, doing business, but it's also about doing it in a free way. The whole history of contracts, as we will get into, is the story of private people taking over business through their own agreements, as opposed to everything being an edict from the king or the czar or the dictator, or you know, under the Soviet 5-year plan or anything like that. It's about freedom in business and in the marketplace that goes along with, you know, freedom in government and self-determination of people to live where they want to and how they want to, as opposed to, you know, having tanks roll in and tell them, you know, how they're supposed to live. And I hope that this is, you know, small beginning of a you know, program. There'll be a great cooperation between University of Alabama and your school and other schools in Ukraine. And I know that people in Alabama are excited to be starting this. And of course, people in America want to help Ukraine, but it's also true that Americans need to learn about what's happening in Ukraine and learn about the importance of it. It's not a country that was typically studied in U.S. universities in history or culture or language classes. And we're going to start, about to start teaching Ukrainian language courses and Ukrainian history and all that kind of thing at the University of Alabama. So we're excited about that. And this class, again, is the beginning, the very beginning of all of that. And I'm glad there's so much interest. I understand, I can't see everybody on the screen. I understand we have 82 students, which is in fact is fantastic. When I teach a course at Alabama, I don't get 82 students to sign up because they say I'm too hard. I'm too hard a professor. So we'll see. I hope I'm not too hard for y'all. And I haven't taught a class before to students who are not don't have English as their first language. So y'all need to let me know if I'm too hard or too fast or too slow or something. If you're having you know, trouble understanding, try to bring it along. You know, studying a law class is a difficult class for something that is not your native language, because deciding issues in law, and especially the way the American and English common law tradition law works, cases can be decided on very, very fine distinctions of language that, you know, really take the smartest and most adept people, you know, of native English speakers to understand. And so we'll be reading a lot of cases from English and American law, and as I said, you know, the lawyers who use those cases to argue in court are often relying on just a, you know, very, very particular, specific, fine distinction between what different words mean. And so that's something we'll have to work on with this class to make sure we, you know, get it to a level that y'all are understanding it. And I hope that we'll have a lot of discussion in the class. And one thing that will help me, you know, understand, you know, what your level of English proficiency. Of course, many people here in Ukraine speak English better than I do. So we'll see how that goes. We're having to sort of create the course a bit ourselves, because you don't have American contract law textbooks here in Ukraine that you can go to the bookstore, university bookstore, and buy like we do in America. So you're gonna have to kind of make up the course as we go along, and with me providing materials to read and as much as I can that y'all can find online to read. I'm going to teach it a little bit the way that I would teach the class contracts in the United States is what we call a first year course, which means in the United States, people go to law school after they finish their 4-year undergraduate degree, and then they go on to a separate school for law school, which is a 3-year program. And in the first year, contracts is a required course that everybody has to take, every student has to take. And it's typically a 1-year long course, meaning 2 semesters and maybe meeting 2 or 3 times a week. We're going to have 1 semester meeting once a week, so I have to condense a lot of it anyway. But I'm going to try to give you a flavor of how the course would be in the United States as if you were an American law student and get the experience. Some of it, when I was looking at the contracts, first year contracts, law textbook at where I went to law school at the University of Georgia, I was looking at it go like, I don't know how much of this the students are going to be interested in, because it's a lot of history and a lot of theory. And actually, I enjoy the history of it. You know, law is really history. When you study law and go back and read the cases, you're reading the history, and the way the law developed is, parallels the way the society and the culture developed. So it's really an important part of the history. But the law school class that they teach in the United States is also a lot of theory. And when I was looking at the textbook, I thought, oh God, these poor students in European may not be interested in all of this theory, because it's not necessarily directly related to what you need to know to actually go into a courtroom and practice law, or go and be a corporate lawyer and draft international agreements for the rights to the movie that your client created, or the contract for a American company to come to Ukraine to rebuild a bridge, or to open a franchise for a company like the McDonald's. I see everywhere that's a international contract agreement that's based on. And I'm sure that that's what y'all really want to learn how to do, more than you want to learn like what is the arcane theory that came from a book in 1608. But we're going to study some of that, summarizing some of it briefly for a couple of reasons. One is that I think it will help y'all to understand how American law students are educated, so that when you're dealing with American lawyers, you kind of know the foundation of how they were trained and what's in their head a little bit. And also the theory is important because it's like the foundation of a building. If you're going to change the building or move the building, you better pay attention to the foundation that is built on. And sometimes to make changes in the building, you need to understand, will the foundation, bear the change that you're trying to make. So so there are reasons to understand the theory. We'll try to get more into the practical aspects of what you're actually going to do as a lawyer. And so I hope y'all will not be so shy all the time. We'll start to talk a little bit and help give me some ideas of what you're interested in. The other thing is that I'm not sure how law school is taught here in Ukraine. In the United States, it's taught by what we call the Socratic method, which means the professor calls on a student, asks them about the case, asks about the reading, tries to drag it out of the student, what it is they were supposed to have understood from the reading. So, and if people want to, volunteer with their comments, or if you have a question, feel free to stop, or if you don't understand something I'm saying, which is highly possible, given his English is not your native language, and lots of times my American students don't understand what I'm saying either, and have to stop me and say, "Can you please explain?" Because we don't understand. But we'll use a little bit of that method of calling on students and asking them to read and respond to questions. And again, that's the way American law students are trained to be lawyers. Let me see. Anything else? So I don't know. There was a article that I wrote for your law journal that meant to have sent around to all of you to read before this class. That could be the basis of our discussion for the first class. Did y'all get that?
Yeah, we did.
The case of Fletcher versus Peck, y'all had a chance to read it? Well, yeah, I know, and I have one brave volunteer there, and I'm glad. Usually they turn out to be the best lawyers. You can't be a lawyer. You can't be a lawyer if you're not willing to speak up. If you want to sit in the back of the courtroom and not speak up, you maybe go try to be something besides a lawyer. Well, good. Well, we have that, and we're going to kind of, y'all probably haven't had much time to read it, so we're going to kind of walk through it in this first class and answer your questions about it, I hope. We can take down that picture, Artem. I think maybe you're already trying to do that. Oh, well, we got the next picture. Yeah, so this is for Fletcher versus Peck. This is a old map. This case that basically started in 1795 and was finally decided in 1810. That can be another thing about the courts. They work really slowly. One of the first things to understand is mentioned in the article. And so our law training and our law system in the United States is built on what we call the common law that we took from England. And Ukraine and other European countries don't typically have the same system. It's more from the Roman law, which is a statutory system, whether Roman Senate would pass a statute and say, this is how these are the kinds of contracts you can have, and this is what you have to have in your contract to, for it to be valid, and so on and so forth. And in the United States, we don't have the same system. We have a system from the common law, which comes from, it's again a buildup of history of what courts decided, and we might be going back to the 1600s, the 1700s, 1800s. That's a little different now because and especially for the sale of goods and a lot of international transactions, we've started actually passing statutes, but a lot of our law operates on the common law system. So if you want to research an issue or you want to go to court and argue a case, you have to study all the previous cases. And there are some advantages and disadvantages to that system. One of the disadvantages illustrated by this case of Fletcher versus Peck is that when your law system depends on the history of the prior cases, have precedential value, which means that if the case has been decided earlier, a court is supposed to try to follow that decision. What does that mean about your law? Well, it means that the case law that you study is from all the cases all the contracts that went wrong, the contracts that turned into a train wreck. And so it's kind of, it's a cautionary tale of don't let this happen to you. Of course, when you're practicing as a lawyer, and like to sometime get a chance to question y'all on, what you want to do and how many of y'all are actually planning to, go and become lawyers and practice law. When you're a lawyer, you really, if you're a contracts lawyer, if you're a lawyer drafting contracts for your company, or you work at a law firm and you have clients and, draft contracts for them, you don't want to go to court because that means your contract went wrong. Something was a disaster. You have something really bad has to happen before you think, wow, the only way to resolve this is I've got to go to court and look at this case and take 15 years to resolve my problem. Nowadays you can spend millions of dollars in court. So the first thing you understand as a lawyer is you don't want to go to court. You just don't want to. But the cases you study as a law student are all the cases that went to court because it was a train wreck. It was a disaster. And then a court has to sort it out and decide. And then you kind of have to, that creates a precedent that you have to follow, but it also creates a signpost for you of, like, as a lawyer, especially as a lawyer drafting contracts, that's how contract forms are created. A lot of the provisions that are in the, international contracts today, when McDonald's signs an international, franchise agreement to have McDonald's in Kyiv, a lot of the provisions that are in there from prior cases where somebody messed up, didn't foresee something, wrote something poorly or confusingly, and they had to go to court and straighten it out. And then from then on, people base their contract on that prior court decision and say, we got to write our contracts to make sure we make this clear, because the time it wasn't clear, it was a disaster. We had to go to court for 10 years, which you don't want to do. So the other side, the benefit of the common law system over the Roman system of just having a very statute that states a very general proposition is that the common law system is very specific, because you have an actual case with actual facts that were decided. And so it's really the facts of the cases create the law. And in a statutory system where you just have a general principle, you're not always sure how that general principle applies to the facts that you've got in the case that's in front of you. In the common law system, you have it very clearly defined, like, this is how the general principle applies in these particular facts. And then you also know never to get into that kind of a fact system again. So let's just take our handout that was sent out to you about Fletcher versus Peck. And this is something that I was asked to write an article for y'all's law journal. So I wrote it as something that we could talk about in the first class, talking about one of the first, and really the first and most important contract law case in the beginning of the United States. And I don't know, again, I hope as we go along, I get a better feel of how much, if anything, y'all know about the history of the United States, but we'll talk about it a little bit. But, we had a, revolution, became free from England. There were 13 colonies along the Atlantic coast, Georgia being one of them, that at the beginning claimed the land all the way from the Atlantic all the way to the Pacific on the other side. Of course, that was a complicated mess by itself, because there were lots of competing claims already not least of all to mention the people who already live there, the Native Americans that we call Indians, because when Christopher Columbus first came to the New World, thought he was going to India. He arrived in North America and found the people, Native Americans, and thought he was in India, called them Indians. So now we call it, for centuries in the United States, we've called them Indians, although they have nothing to do with the country of India. And now that's a term that's not really favored, and because it's not based in reality. And so people say Native Americans or something else. But anyway, those people were there. And also, it wasn't just the English colonies that were there. There were Spanish colonies, there were French colonies, there were, other people all over the place with competing claims to those lands. And the case about, Fletcher versus Peck has to do with all of that confusion. The picture that's up now, we'll get to it later. That's kind of showing what the English did to the land, especially Georgia and Alabama and Mississippi, the states that we're talking about in the South, which is where I grew up. I was born in New Orleans, Louisiana, you might have heard of, and I've lived in Georgia, Alabama, and Mississippi. It's all naturally covered in forest. This picture shows what happened after the English settlers got there, and their idea, and the Native Americans who lived there before lived in the forest. They hunted and they gathered and they fished and they lived off of the forest. This is what happened when the English settlers came. They knocked down every tree in sight, and they created this kind of a landscape for farming and timbering and everything else. But well, let's skip over some of this, but let's talk about what the case arose out of, which was the Yazoo land fraud. The Yazoo was the name of a river in Mississippi, and we start in with our Socratic method. So we have a brave volunteer who can explain to me, see if you understand the reading of what the Yazoo land fraud was. What was that about? What caused that? Anybody brave enough? Okay, well, we'll get you there. Anyway, we'll just walk through this article. You probably had much time to read it, but the early Georgia legislature, and think about it, so American history, we declared our independence from Great Britain in 1776, fought a Revolutionary War, muddled along with a kind of ineffective government after that for a while. It was not until 1789 that we established what is still the Constitution, which is the founding legal document that everything is based on. And so you're going to, study American law. That's if you don't understand that, that's the first thing you need to understand, is that the Constitution is the basis of everything, and that's the ultimate final law. And if you go all the way up to the U.S. Supreme Court, that's what you're arguing, is a very fundamental legal question from our Constitution. And I'll just run through the history a little bit. So if you see on the map, it shows now the state of Georgia, which is pretty much, those are the borders of the state of Georgia today. But then it shows some lines going out from that above where it says Yazoo, Georgia land controversy. All that land has those shaded areas. Those are now the states of Alabama and Mississippi next door. So you can see where the University of Alabama is, right next door to the state of Georgia. And Georgia claimed all of those lands. And so think about this, how new the country was. 1789 is the first year we have really the United States under the US Constitution. 6 years later, in 1795, this ragtag legislature, the Georgia's version of the Rada, passes this bill to sell all these lands to the West, even though they were also claimed by Spain, claimed by France, claimed by Native Americans, given by treaties to Native Americans, sold all those lands for just a ridiculously, basically 1 cent an acre, which I guess is like a half a grivna. A half a grivna for an acre. An acre is not quite as large as a hectare. So it's a fair amount of land. You know, if you had 100 acres, you could, have a nice size farm. That they sold that 100-acre farm for 50 grivna, which even in 1795 was ridiculous. Why did the legislature agree to sell that? Because they were bribed, because some corrupt businesses came to them and said, we'll pay you, we'll cut you in on the deal if you will sell this land to us for a price that's just ridiculously low. And so that's what happened in 1795. When that was discovered, the people of Georgia were outraged. It was not quite the Maidan Revolution, but they rose up in protest, and in the next election voted the governor and a lot of those legislators out of office, and then passed a new law repealing that whole transaction. Of course, another interesting thing is, at least in the United States today, we don't think of the government being in the real estate business of selling, developing real estate. That's something private people and private companies do. So that made this case a little more interesting, that it was the government, the state government, that was governed by this contract, which usually, in the law as it developed in England, a contract, again, that was something supposed to be outside of government, and that's something private people, private businesses, and private individuals went back and forth regulating their business affairs by contract, and it wasn't necessarily the government that was in the business. But this case established that the government in the United States is also controlled by the same rules of contract as private individuals. And though that might seem long ago and far away, that it may have some direct application in our future as both the U.S. government and private American companies become involved in the rebuilding of Ukraine. So we will see about that. So anyway, the legislature sold all this land, gave it away. Next legislature comes in, passes a law saying, forget that transaction. That was terrible. That was corrupt. That was criminal. That was all done by bribery. So it should all be undone. But as the article points out, this quickly turned into a giant mess that had to be straightened out by the U.S. Supreme Court. And you can understand why, because if you could go buy a hectare of land for 1 grivna, that might just go wild, and it did. And so you notice this case was about the state of Georgia and land that was sold next door in Alabama. The litigants in the case were from where? Anybody can remember from the reading where the parties in the case, Fletcher and Peck, were from, and understood what that meant? Okay, well, we don't have any brave volunteers today, but anyway, this will give you a little idea of how, this works in a U.S. contracts class. And y'all didn't have much time to do this reading, but tomorrow I'll send y'all the reading for next week, which will hopefully have a little more, be less historical, have more application to practical contracts. But y'all will have a longer time, a chance to read it, so that next week when we convene, I'll be able to, ask you questions, and some of y'all will be able to hopefully come out with the answers. So that's the way the legal education method works in the United States, is the professors dragging the answers out of the students. And the other thing is, in the United States, if nobody bravely volunteers, the teacher will call on people. And that led in the United States leads to lots of embarrassing moments in law school when students, as I know it never happens with any of y'all, but it has happened sometimes, that the students haven't done the reading. And then when they get called on by the law professor, it's a very embarrassing questioning session when the professors ask them a series of questions. And they're like, I don't know. And then finally have to admit, well, I didn't do the reading. So that's nobody wants that to happen. Let me see, how are we doing for time? Well, we're getting, time is flying here a little bit. So we will skip over some of this, but I hope y'all notice that, talk about going to court, and ask you, whenever you look at a case, you just ask me, why did this case go to court? Because, as I was saying, the last place, if you're in business, you're buying and selling property, trying to make money, the last place on earth you want to go is to court to have some judge, decide your fate. You want your business transaction and your contract to work so that you don't have to go to court. It's like, what in the world possessed these people in between 1796 and 1810, when this case was decided to go to court? You notice Robert Fletcher, the man who bought the land. By the way, the answer to my question, so this case is arising. This is a map of the very southern part of the United States, Georgia and Alabama. And I should have had a map of the United States, but y'all probably familiar with it. The litigants in this case who brought the case were from New Hampshire and Massachusetts. The case was actually originally filed in Massachusetts. You're like, why in the world was, Massachusetts, that's where Boston is. It's way up in the north, freezing cold. All this land is down in the south, in the hot forest. And it's like, how did this case get started way up next to Canada, where the case started? And that's because this land was sold at such a low price that it just created this frenzy all over the country. If you could, like I said, if you could buy a hectare of land for a grivna, and buy 1,000 hectare plot to put your dacha on, for 1,000 grivna, which is what, $25 today, you would want to buy that 1,000 hectares for $25. And so, why in the world is, Fletcher complaining about his deal that he paid $3,000 for 13,000 acres, and he went to court and fought for 10 years to try to undo this land contract, sale of land contract, when he paid $3,000 for land that is worth, depending on where it is and the condition, it's worth a minimum of $13 million today, and might be worth as much as $13 billion, which he got for $3,000 back in 17 something. And so why is he going all the way to the U.S. Supreme Court, which is, I have taken cases to the U.S. Supreme Court. It's incredibly expensive, incredibly time consuming. It's like, what in the world are these people doing? And some of it goes back to, the weird way of thinking. And when you're dealing with, other cultures and other times, and sometimes, other countries, you have to understand their mindset to do these international deals and transactions. And that's part of why the theory of contract, in this time is important, because back in the early days, when the doctrine of contract law was developing, one of the things they thought that you could go to court to sue somebody on was for the breach of the promise. And it didn't really matter to them, it seems from the history, it didn't really matter to them sometimes they got a good deal, because Robert Fletcher, who bought this land, he got a good deal, but he felt like a promise to him was broken. And that was the basis of being able to go to court and sue somebody. And we'll see that that's not really the case anymore, but that was the initial theory of contract laws. He made a promise to me and he didn't keep it. Even though I made $13 million on the deal, I'm going to take him to court and sue him because he broke his promise. And just think how crazy that seems to us. It seems to us Americans, that seems crazy. I don't know if it seems crazy to y'all, but that's the way these people were thinking, and that's what created this case. And like I said, when if you're hoping to be an international lawyer, you're going to have to spend a little time in working out contracts with people from other countries, understanding their mentality. And this case is a good historical example of it. Of course, it's a very dramatic history when they discovered the corruption. And of course, corruption by itself, that's an issue for us all in the world today. We all need to get the corruption out of our countries. And this case shows that the corruption was right there at the very beginning of Georgia, and the people were so outraged by it, they threw all the people out of office, and like sent Yanukovych to Moscow, get out of here, and then actually physically burned the legislation that had enacted this land transaction. And but to make a long story short, because we have got just about a half hour left, and I'm gonna try to let y'all talk some. The court, and maybe y'all read this again and be prepared to talk about it next week, because I might ask y'all some more difficult question, more subtle questions about it, that I want to start training your minds to see these issues in the cases, because you're going to be a good lawyer. You got to look at a case. You got to look at it and go like, these are the issues in the case, and this is what, you know, had to be decided. And you're also, if you're going to be dealing with U.S. law, you're going to be, you know, arguing your position based on citing a bunch of cases like this. You might not have to cite Fletcher versus Peck, but you're going to have to cite some case that supports your argument. And you're going to, sometimes to do that, you're going to have to understand some, you know, very subtle issues in the case. And not only in the facts of your case, but in the way the courts decided these cases. And I'm just going to, let me tell you one more thing about American law and studying American law. The way, and I'm going to try not to do this to y'all, the way law is taught by law professors to American students is kind of almost like a mystery. You read the cases, the professors ask you a lot of questions about it, trying to make you think about the case and what are the issues in the case, what's underlying the decision, and maybe what's logical about the decisions or not. You know, what I would like to talk about next week is, in a lot of ways, this decision in Fletcher versus Peck is not logical at all. And it's something to understand. And it's something we fight with today in both of our countries, is that sometimes the courts are not really deciding the issues according to the law. They're deciding them according to some politics or, you know, in this case, as I argue in this article, they really, this corruption created such a financial mess in the United States, because as I was saying, the land is in Georgia and Alabama. The litigants, the parties who are fighting in court, are from way up on the Canadian border, because the land was so cheap that everybody was swarming to try to get in this deal. Like, you know, can I get a hectare of land for 1 hryvnia? You know, that just created a frenzy. And so the court, in a lot of ways, is just cutting the country's losses and saying, you know, this is a giant mess. This has created a lot of unfairness. It's got a lot of corruption underlying it. But for us to create a stable economy in our country, and a predictable business climate, you know, we have to make this decision that we're not going to honor this decision by the Georgia legislature, which, when they went back and repealed the original sale, you know, undid lots of other transactions, because they had the original sale where they sold the land to the corrupt people who bribed the RADA members, but then they went and sold it to a bunch of other people, and they sold it to other people. They sold it to other people. As you can see, this case is decided 15 years after the original sale. So there's a lot of land that has changed hands in the meantime. And the Supreme Court is really faced with this mess. You know, can we really undo all of these transactions? And they really make a very pragmatic, practical decision that no, we can't allow that to happen. You know, we have to have more stability in our economy. And but because of that, there are a lot of things in this case. It's not a case you would use to argue your position today, because there are so many things logically wrong with it. So, for example, the main reason the U.S. Supreme Court says we can't undo these several years worth of different land sales back and forth is because the people, other than the original corrupt people who bribed the legislature, the legislators, the RADA members, all these other people were innocent. They didn't know about the corrupt deal. They didn't know about the bribery, and they paid good money for the land without any notice of the bad criminality that underlie the whole thing. And so we just have to recognize all of those transactions. How many of you believe that, well, here, let's find this in the, and Artem, if you are with us, I think you have this paper. Let's get one brave reader going today to read what the court said about why they couldn't overturn all of this. Okay. Actually, I tell you what, it'll be simpler today. I'll be the brave reader. I'll show y'all how to do it. And I'm going to go down to is near the conclusion. As you can see in this article, I didn't make y'all read the whole article, but you've noticed if you look at the paper, there's a link to the whole case. So if anybody is curious enough to want to go read the whole case of Fletcher versus Peck and see all the argument back and forth about it, you can, there's a link where you can do that and find the whole case. But I'm gonna read to y'all this pronouncement from the Supreme Court justices in 1810. It's down near the end of the article on the page right before the conclusion, and they address the corruption that was underneath this contract to sell the land. And the court said, it would be indecent in the extreme upon a private contract between two individuals to enter into an inquiry respecting the corruption of the sovereign power of a state, if the title be plainly deduced from a legislative act which the legislature might constitutionally pass, if the act be clothed with all the requisite forms of a law, a court sitting in a court of law cannot sustain a suit brought by one individual against another founded on the allegation that the act is a nullity in consequence of the impure motives which influence certain members of the legislature which passed the law. So they say, we're not going to look at the bad motives of the people who passed it. And then there's another section here, if I can find it. I got too much paper here myself, and I might not have printed that part out. But anyway, the court makes a very strong statement that they can't undo all these land transactions because all of the, oh yeah, here it is. So they're talking about all of these purchasers down the line that they don't want to undo all of their contracts. And if you think about the implications of that, the state, the government is going to undo a lot of private contracts entered between individuals. And the Supreme Court says about the land that had been sold for a valuable consideration, it had all been surveyed and purchased, And if the original transaction was infected with fraud, which it was, these purchasers did not participate in it and had no notice of it. They were innocent. Yet the legislature of Georgia has involved them in the fate of the first parties to the transaction. So they're saying you can't, all these people down the line, they're innocent. You can't possibly overturn their contracts by which they later bought this land. How many of y'all believe, and this is a very sweeping statement, and we know that there have been hundreds and maybe thousands of contracts selling parts of this land. The original parcel that was sold was 35 million acres. And so they're selling it off to people 100 acres, 1,000 acres at a time, hundreds of these deals. How many of y'all believe this sweeping statement by the court that none of these people subsequently bought land knew anything about the corruption or the problems with the transaction? And for next time, we might get a couple of y'all to be lawyers and argue that and think about, how would I argue it? I'm going to be an American lawyer and I'm going to go into the U.S. Supreme Court. And I'm going to argue, you can't overturn this contract because none of these people knew about the corruption in the legislation. And then somebody can argue the other side. Think of how you would argue the other side. Like, of course people knew, and there's no way that none of the people knew about this problem. Okay. And we have a few minutes left. So, Artem, if you can, yeah, thank you. If you can take the document down where, maybe, can I do it? I don't think so.
1 minute, I'll text him.
Oh, okay. I didn't know he's not with us. That's okay. So anyway, in the time that we have left, I'm gonna let y'all talk and tell me, does anybody have any questions about what we talked about? Is there anything you didn't understand? Like, what in the hell were you talking about? Or I don't understand your English. Or...
Так, дивіться, шановний пан професор каже, що ви можете, в принципі, задати питання по ходу лекції. Будь ласка, у кого є питання, задавайте.
Dear professor, everything was quite clear, and we're very grateful to you for this lecture. I understood everything, at least.
Well, you're way ahead of my students in Alabama then, because they never understand everything. But thank you. Do any of y'all have any questions about the class or comments about what I'm interested to hear what you came to the class expecting to learn. I know you didn't expect to get, a history lecture the first day, but like I said, that's the, trying to give you a flavor of how contract law is taught in the United States. What were you expecting? What are you expecting or hoping to learn in a course about U.S. American contract law?
Дивіться, шановні студенти, може ви скажете, чого ви очікуєте, да? Чи може вам щось було б такого дійсно цікавого, можливо, дізнатися? Задавайте питання, будь ласка, ми з цього якби комунікуємо. Пан професор чекає.
Dear professor, it would be great if you give us some practice knowledges, because history and theory is very good, but as we know, theory and practice is kind of differ. So it would be great if you give us some practice knowledges from your own practice, maybe, or something like this.
Yeah, thank you for that. And I will do that. So, we'll talk about cases that I've worked on and actual, international contracts that went to court and the reasons they went to court and the different clauses that need to be in an international contract and how they go right and go wrong. So yeah, I understand that y'all want to learn how to practice.
I would say that history part was interesting too. For me, I like history.
Thank you. I like history too. I teach more history than law. And like I said, I think it's important to understand that law actually is history. The way the law is today has developed over time in history, and is a product of history. Anybody got another?
Professor, thank
Yes.
you for being with us today.
Mr.
And
Stephen,
talking
I have a
about the
question.
expectations. Can you hear me?
I can hear you. Yeah, but somebody was trying to ask a question.
Okay, I'll go first. Talking about the expectations, as you mentioned, we are in a Roman system, legal system, and it's extremely interesting to get more deep into common law, and especially to gain some practical techniques that we can apply in our system, in our legal system. So it would be really interesting and useful to hear from you some insights, some keys to how to win the cases, and
Right.
How to be successful lawyer. That's all. Thank you.
Yeah. Well, yeah, thank you. And some of that is, and I'm sorry, I'm going to try to learn all 82 of your names. Sometimes that involves, and part of the reason for a little bit of this history lecture is it involves understanding both systems. You might only practice law in Ukraine and not have to worry about it, but in today's world, a lot of you are going to end up or maybe want to practice internationally, which means you have to understand your system and you have to understand our system. Most people want to do business in the United States. A lot of United States companies, will come here. Many are here, and more will come. And especially if we get to a stage of chasing Putin out and rebuilding all of the destruction. And so, it'll be important for you to understand both ways of thinking. And I know the U.S. law. I don't know, the Ukrainian law as well. As I hope as we go along, one thing we can develop is like, what are the differences between the U.S. common law system and the European Roman law system here in Ukraine. And some of you students, you might know more about the Ukraine. I don't know how far you are in your studies. You might know more about the Ukraine law than I do. And so that's why I think it'd be interesting is as we're discussing and you hear me describing something about the American law or about the common law system, and you know that that's different from your system, that would be useful to speak up then and say, point out the difference between the American system and the Ukraine system, because for people who want to do business back and forth between the two countries, it's going to be important to understand both systems and the differences between them. And I hope that's something we can develop in the next 14 weeks of this class. And there was somebody else who had a comment.
Yeah, that was me. Artem named my expectations from your lectures, but it would be great to hear your personal successful stories of winning cases in corporate law also in the future.
Sure. Yeah. Well, as I said, some of the lessons you can learn from the successes, and some of the lessons you can learn from the things that were not successful. And sometimes it's interesting. There's, when one important contract that you'll have as a lawyer is the contract with your client. As an American lawyer, the first thing you do is have a representation agreement. And one of the things that's in every American lawyer's representation agreement with the client is like, there's no guarantee of what will happen, and there's no guarantee we can win. You can have a case where all the facts are on your side, all the law is on your side, and some crazy judge, for some reason that is not within the bounds of law or your ability of legal understanding, will rule against you anyway. And that's another reason sometimes, as I said, to talk about the theory, because sometimes you have to go and change the law. Sometimes you have to, overturn a decision. That happens frequently in the United States, that a court will make a decision that people are like, that's crazy. That's not following the law. And in that case, we have to, go to the legislature, go to the Congress, and have them pass a law that basically overrules that court decision. And that's when understanding all this history and theory can be really important, when you have to reform the law. And of course, Ukraine, there's a lot of experience in the last few years of trying to reform laws. So, and I've done, some international business cases and intellectual property cases and international contract cases. My actual main legal expertise is I guess you call it, anti-corruption in whistleblower and racketeering laws and things like that. And that's, that anti-corruption is certainly an area where Ukraine has been, involved in a lot of efforts to reform and improve the system. And of course, that's, as you see in this case of Fletcher Peck, that's not necessarily just a theoretical thing. That's a real practical reality of you have to have that corruption reform to be able to conduct business in a country, which I know most of y'all, if you want to be lawyers, that's what you want to do, is go out and do, successful business. And but it's part of the point of Fletcher versus Peck is that's not completely separated from these political issues that we have to deal with, and corruption is one of them. Any other questions or comments?
Who was the biggest client?
The biggest client, maybe Merrill Lynch. Y'all know what that is? It's an big investment firm, Wall Street investment firm in the United States.
We will Google that.
Okay. And another one, a French company, Dassault. They're a major French company. They make everything from computers to Mirage jet fighters to, I don't, you know, everything. We could use some of the Mirage jet fighters here right now. Anything else?
What can you tell about the future of European? Do you think it can be progressions?
The future of what? I'm sorry, I didn't understand.
European.
Oh, the future of European. Well, that's an interesting question. It's something I came here to work on, and there's going to be a lot of, you know, obviously there's been, you're talking about the city or the area, you know, and well, it's the university as well, you know, a lot of damage and destruction that there's going to be a lot of legal effort that I'm involved in to try to remedy. That's something that we're working on very hard right now. I don't know what to tell you about the future, except for that we're working on it. We will see how it goes. We're hoping for success. It's kind of a different legal area that nobody expected to be in 2022 and 2023, to have this kind of Hitler invasion of the country next door. So we're hoping to use the U.S. courts, you know, some of the places people have gone to, you know, The Hague and different places, or maybe not as responsive. Honestly, the U.S. courts, one thing to learn, it's helpful to learn about, it's not necessarily contract law, but if y'all want to get into practical knowledge and experience, we might divert from just talking about contract law to talking about like understanding the court system, because that is, you know, very critical to having success, to understand, you know, what a country's court system. So the United States court systems are much more used to dealing with these kinds of problems of massive damage and involving, you know, billions and trillions of dollars. You know, one of the cases that I worked on is actually, I was what they call the clerk for a federal judge in the United States. When you graduate from law school, you can go for a year or two and you work for one of the federal judges, and maybe like even a U.S. Supreme Court justice. And as the clerk, you basically, it's a little bit frightening. You act as the judge because you're really writing the opinions for the court, and the judge will, you know, look at it and say, yeah, that's okay, or that's not okay. But the clerks are basically doing the work. And when I was clerking for a federal judge, I don't know if you ever heard of this, but there was a case over silicone breast implants that was a worldwide case. And this case was based in the federal court in Birmingham, Alabama. And I was clerking for the judge, Sam Pointer, who oversaw what we call in the United States complex litigation or class action. So this was one case involving literally millions of women around the world. We didn't know what was going to happen one day, the next. You know, one day we'd have some women show up from Brazil, and the next day, you know, women from Japan. I never knew what was going to be next. But the point is that United States courts are much more accustomed to dealing with these kinds of massive cases of just massive damage and massive amounts of money. And the good thing is that they're award more money, and that's something important to understand. So I've practiced in cases in Canada, and there's a little bit like what I was telling y'all about with Fletcher versus Peck. Is like, why, you know, why do these people, you know, this guy who brought this case, he probably today to go to the U.S. Supreme Court, you're going to spend hundreds of thousands of dollars to try to overturn this land transaction. Why don't you just keep the land you spent $3,000 on? You spent much more than $3,000 going to court. And I've, practiced in Canada. I speak French, and so he worked in Montreal. And in Canada, their courts don't award that much money. They'll have a big fight, and people will litigate it for years, spend lots and lots of money, years of that. I mean, that's the other thing you have to understand. As the lawyer, it's fine if you're doing all this work and getting paid. For the client, it's a huge time commitment to go to court and sue somebody. It's like that takes over your life. That's all you do is work on your case. And people in Canada, they do that. They litigate things for years. They pay lawyers thousands and thousands of dollars. And then the courts end up they decide in your favor and award you $5,000. And you're like, wow, I just spent 5 years fighting in court to get $5,000, 5 years for $5,000. And I asked my Canadian friends and lawyers, like, why do y'all even do, and that's one reason that American law students are taught all of this theory of contracts. A lot of it is economic theory, and you're thinking about the economics of it. Is it worth it to go to court, spend 5 years and pay lawyers $500,000 to win $5,000? It's economically insane. And the Canadian lawyers say, you have to have a lot of hate. You have to really hate the people and want to fight them in court. And it's just like this guy, Robert Fletcher, spent all this time going to the U.S. Supreme Court. He got the land. He should have been happy. He's got 3,000 acres of land. Or he had 13,000 acres of land. He paid $3,000 for it.
That's a robbery.
$13 million. But, he went to court because the guy broke his promise to, so, and that's why I say not only understanding the theory of the law, but understanding the mentality behind it and the mentality of the litigants. Anyway, long way of saying we hope to be able to bring cases in courts in the United States where they will award Ukraine a lot of money and pay it, make the Russians pay it. So I think we're actually right at our time. So that's a good place to quit. Not sure how I'm communicating with all 82 of y'all, but I'm going to talk to my friends that have been so kind to me at your university and the administration there and helping me. We'll figure out a way to send y'all all the material to read for the next class. And I hope we'll have another good discussion then. And thank y'all. And thank y'all for hosting me in Ukraine and at European.
Thank you too.
Thank you, dear Sir Steven. So it was really great lecture for our students. So I hope maybe some of you can tell few warm words to our professor. So you're welcome.
Hello. I haven't a question for you, but I want to say thank you. It was so interesting, and it's actually a so interesting experience for all who's here. So thank you very much.
Well, thank all of y'all. And although we're doing this by Zoom, I'm actually I don't know if y'all knew, I'm in Ukraine now working on these cases. So hopefully we maybe can find a way to have a meet in person at a coffee shop or something, since y'all can't go to class. But anyway, I've looked forward to talking to y'all for the rest of the semester, and I will talk to you next week, if not before then. Thank you.
Thank you.
Thank you. Thank you so much.
Bye.
Have a nice day.
Thanks, you too.
Goodbye. Thank you.
Thank you.
Thank you.
Goodbye.
Thank you.
Thank you.
Goodbye. Thank you.
Oh, thank you.